Hello, my name is Ricardo Amigo, partner of the firm Berton Moreno IP Law in Buenos Aires, Argentina, and you're listening to the IP Fridays podcast.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzan and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
My co-host Ken Suzan and I are welcoming you to the last edition 159 of IP Fridays in the year 2024, before the holiday seasons. We wish you all happy holidays and a successful year 2025. Our interview guest Ricardo Amigo is an IP lawyer in Argentina and will give us an update on the recent changes of trademark law, including the new Patagonia issue, the new trademark opposition procedure, and much more. Before we jump into this interview, I have news for you. First of all, my book Markenrecht einfach, translated into Trademark Law Made Simple, on trademarks will be published in March 2025. Many entrepreneurs and decision makers feel overwhelmed by trademark law and make unnecessarily expensive mistakes, often out of ignorance. I'm changing that with my book. I explain trademark law to the readers in an understandable way without legalese and show the readers how to recognize risks at an early stage and how to protect and enforce their trademarks securely. My knowledge from over 20 years of experience in this field will help the readers to make the right decisions with confidence. The link to the book is in the show notes. The European Patent Office has released its updated guidelines for examination, set to take effect on March 1st, 2025. These revisions incorporate recent legal developments, user feedback, and the latest case law to ensure greater clarity and consistency in patent examination. By refining procedures and clarifying key points, the EPO aims to improve user experience and enhance the quality of granted patents. Users are encouraged to review the changes, as the guidelines serve as an essential reference for navigating the European patent system. The United States Patent and Trademark Office has announced changes to its patent-related fees effective January 19th. These updates will impact various patent-related services, including filing, search, examination, and maintenance fees. The adjustments aim to reflect current cost recovery requirements and continue supporting the high quality of the US patent system. Stakeholders should review the new fee schedule to ensure compliance and budget accordingly for upcoming filings and maintenance activities. The European Union Intellectual Property Office, EU-IPO, has released the new report on the state of online piracy and copyright infringement in Europe, revealing that while overall piracy rates have declined, challenges persist. In particular, TV content accounts for half of all digital piracy, with viewers tuning into illegal TV content 5 times per month. To address these issues, the report emphasizes the importance of ongoing enforcement efforts, consumer education, and the availability of legal, affordable, and high-quality content. It also highlights the need for international collaboration to protect creators' rights and nurture a healthy digital content market. Now, let's jump into the interview with Ricardo Amigo with his update on the IP laws in Argentina.
Our guest today on the IP Fridays podcast is Ricardo Amigo. Ricardo is a partner at the Berton Moreno IP law firm located in Buenos Aires, Argentina, and has been working as a lawyer specializing in IP since 1989. Ricardo represents local and foreign clients alike in almost all industries and has broad experience in trademark law, both prosecution and litigation, as well as copyrights, industrial models, and designs, patents, genetically modified organisms, biotechnology, and entertainment law issues. He is a member of the International Trademark Association, including its famous and well-known Marks Committee, the Argentine Association of Industrial Property Agents, and the Colegio Público de Abogados de la Capital Federal. Ricardo graduated as a lawyer from the University of Buenos Aires in 1994 and attended the Intellectual Property Summer Institute at Franklin Pierce Law Center in 1996. Welcome, Ricardo, to the IP Fridays podcast.
Thank you, Ken. Thank you very much for inviting me.
Excellent, Ricardo. So I've heard that there's been some recent developments in trademark law in Argentina in the last year. Can you share some information with our listeners?
Yes, sure. There was the most relevant new issue that occurred that affects trademark rights in Argentina was that the Argentine government in 2023 applied for the term Patagonia as an emblem under Article 6 ter of the Paris Convention. And on September 30 of the same year, 2023, the World Intellectual Property Organization recognized in favor of the Argentine government the emblem Patagonia. So that is a very big issue for many trademark owners in Argentina that have acquired rights over trademarks, including the term Patagonia. This emblem was objected by 33 countries, including the US, but it was very, very important that Chile, our neighbor country, one of our neighboring countries, objected too, because Patagonia should have never been granted as an emblem to Argentina, since it's a geographical area which we share with Chile. So the south cone of the South America, which is what is well known as Patagonia, is shared by Argentina and Chile. So of course Chile objected that the Argentine government could obtain this term as an emblem.
Now, Ricardo, when you say that they obtain the term as an emblem, what does that mean practically?
Practically, the most important issue is that the Argentine Trademark Office, based on the obtention of the Argentina of this emblem, has been rejecting all new trademark applications that have been filed in Argentina since September 30, 2023, that include the term Patagonia. So even if you are a trademark owner that you already hold trademark rights over the term Patagonia, or Patagonia as a combined trademark with a design or with a slogan or wherever other additional element, these trademarks are automatically objected by the Argentine Trademark Office and rejected. So even though trademark owners have acquired rights for many, many years, if they have a family of trademarks and want to file for a new design that include Patagonia, that trademark is gonna be rejected, even though they already had another trademark right in the same class.
Wow.
So that's something very disturbing for trademark owners, Argentine companies, Argentine individuals, US companies. This affects to all of them. So that's been a very relevant issue, because we're dealing with acquired trademark rights here.
Yeah. What are there any legal remedies that trademark owners have so they can fight back, or they just have to live with the ruling?
What's been happening is that when the Trademark Office issues an official action rejecting the trademark, you have as a tool, you can file an answer to that official action with all the arguments at hand, principally that it's you already have an acquired right, but the trademark office does not take any, does not even consider those arguments, and they automatically reject the trademark. So the only legal remedy trademark owners would have would be to go to court and have the administrative ruling reversed in court. And basically, under arguing that it's not constitutional what the Argentine Trademark Office is doing, because you already have acquired rights, and those rights, property rights, are recognized in the Argentine constitution. So that is something that unfortunately we do not know how it's gonna, what the first ruling is gonna be. But I believe that eventually the judges will rule in favor of the trademark owners, and the trademark office eventually will have to change their point of view regarding regarding the using the Patagonia as an emblem to stop new applications.
Yeah, we'll have to keep a close eye on that ruling. Do you think that might come out in the next year or two?
No, I don't think it's going to come out in the next year, because I guess that the complaints were filed in 2024, and this is going to take at least 4 years until there's a ruling of the court of first instance. So the Argentine government then may appeal, and it can go all the way up to the Supreme Court. So we're talking about at least 7 or 8 years until we have a ruling. So unfortunately, that's the current situation in Argentina.
Yeah, we'll certainly have to monitor that and see how the court rules, or the courts in the future. So what do you consider the main issues that a trademark owner should address when they want to seek protection in Argentina? Are there any sort of rules of thumb or best practices?
Well, first of all, not use an emblem as a trademark, so you don't have you don't have this problem now. But the most important the most important tip that I would suggest for any foreign company seeking trademark protection in Argentina would be to conduct a search, at least an identical search, just to know if to clear the intended trademark in the class of interest and in any other related classes. But in my experience, it is always better to conduct what we call a complete search, which includes phonetical. It's a phonetical search. So there you're gonna end up finding trademarks that not only the identical trademarks, but trademarks that could be considered confusingly similar in the class. And in the last years, with social media being so important, I would also conduct an internet search for social media, because we found out that there are many trademarks that are not being registered, but they are being used in Argentina. So you don't want to find yourself applying for a trademark, starting using it, and then having a claim by a third party who claims that they have a better right because they've been using it for many years on an unregistered basis on social media. So searches on the register are very important, but searches for social media are also nowadays very, very important.
Yes. Now, Ricardo, I know you have many years of experience with trademark enforcement matters. Is it important to obtain a registration in Argentina in order to, enforce trademark rights there?
Yes, it's in Argentina. In Argentina, the Argentine system adopted the attributive system, whereby the ownership of a trademark and the right to its exclusive use are obtained through registration. There are cases where Argentine courts have granted protection of unregistered trademarks based on notoriety and other significant use evidence. It doesn't mean that you have to register a trademark to use it in Argentina, but you would be in a much better position to enforce those trademark rights against third parties if the trademark is registered. For example, if in order to obtain an injunction in court, the judge will, in most of them, I would say 80% of the cases, will grant the injunction on the basis of a registered trademark that is being infringed. In very, very limited cases, they would consider granting an injunction on an unregistered trademark. You would have to prove specific use over the years, that you have a better right. So that's the main reason why it is always better to have the trademark registered.
Mm-hmm. And let's also take another step in the enforcement analysis, and that is the trademark opposition system in Argentina. I understand that it was modified a few years ago. What are some of those changes that you can share with us?
It was modified a couple of years ago in 2018. The previous system, when an opposition was filed against a trademark application, that application was automatically blocked by the opposition, and the applicant had to undergo negotiations with the opponent. If no agreement was reached between the parties, the applicant had to commence pre-trial mandatory mediation proceedings in order to have a last opportunity to reach a settlement face-to-face with the opponent. And if the mediation proceeding did not bring about the desired result, the applicant had to file a court action seeking to have the opposition declared ill-founded, as otherwise the application would become abandoned. So it was the applicant had the burden to move along with the negotiations and with the court action if he wanted to keep his application alive and have eventually a court ruling that the opposition was declared ill-founded. What's changed in the new system is that after the opposition is filed, there is a very brief negotiation period of 90 days between the parties, and then the Argentine Trademark Office notifies the opponent to ratify the opposition and file additional arguments. So what's changed is that the opponent has to think twice before filing an opposition, because they will have to ratify, file additional arguments. That demands a lot of time and costs, and the ruling will not be through a court, but through the Argentine Trademark Office examiner. So it's an administrative ruling rather than a court ruling, as was in the previous system. So both parties have to undergo what would be the equivalent of a judicial proceeding. The opponent has to ratify, file additional arguments. The applicant has to reply to that ratification. Then both parties need to file all the evidence that they offered in their opening briefs, and they have the final stage to file additional arguments before the ruling. If the applicant, if the Trademark Office decides that the opposition is well-founded and decides to reject the application, the remedy that the applicant has is that to file a direct action before the Court of Appeals. So it goes directly to second instance. It doesn't undergo first instance, and therefore the proceedings are shorter than in the other system, where you were facing 4, 5, or 6 years of litigation. So as you can see, the burden is now on the opponent and not on the applicant. So that's a very, very important change, because it brought down the amount of ill-founded oppositions that were filed in the past. So, in my opinion, it's a very important change that, at the end of the day, benefits the applicant more than the opponent. If we're talking about an ill-founded opposition, of course.
Yes. Ricardo, let's talk about trademark renewals in Argentina. Is it necessary to declare or prove use in Argentina in order to keep a registration alive for purposes of renewal in Argentina?
Yes, it's necessary to prove. You have to file an affidavit where you declare under oath that you have used the trademark in Argentina during the last 5 years. It's a declaration under oath. It's not that the Argentine Trademark Office will examine if what you're saying is it's true or not. But you need to have a valid renewal. You need to use a trademark and file the declaration of use in order to be able to renew it.
Mm-hmm.
So another modification that of the Argentine trademark law is that you need to file also a midterm declaration of use. So when the trademark has aged 5 years, you need to file a declaration of use, and that is an indication, of course, that you've been using the trademark and avoid potential cancellation action for lack of use that a third party may file. So that's also a very important tip that we usually recommend the clients, that they use the trademark, that they don't wait until the renewal, which is 10 years, but that they use the trademark within the first 5 years in order to meet this requirement and to be in a better position to fight against a cancellation action.
Mm-hmm. Ricardo, what about partial cancellations in Argentina? Can a trademark be partially canceled for lack of use in Argentina? And if so, can you briefly describe the process?
With the new Argentine trademark law, that is possible. It was not possible before. When you filed for a cancellation action, you canceled the whole trademark. Now you can file for a partial cancellation action in order to cancel for one good or certain goods or a service. So that's something that a third party with a legitimate interest, it's very important to have a legitimate interest to be able to claim, to file the cancellation action. And then the cancellation action, the Argentine Trademark Office serves it on the applicant, on the trademark owner, in order to defend himself by filing proof of use. The good thing about the new article regarding cancellation action is that you could defend yourself of a cancellation action if you use the trademark in a related good or service. So, for example, if an alcoholic beverage company obtains the registration of a trademark in class 32 for beers and in class 33 for wines and other alcoholic beverages, and a third party tries to cancel the registration in class 33 or in class 32, and the trademark owner used the trademark for wines but not for beer, they're going to be able to defend the cancellation action in class 32 for beers, even if they didn't use a trademark for that specific beverage. So that is very important. Of course, it is always very difficult to determine what can be considered a related good or a related service. So that's something that has to be analyzed in each specific case and in each specific ruling.
Mm-hmm. Ricardo, we're coming near the end of today's interview. I want to close on the topic of famous marks. How are well-known brands protected in Argentina?
The well-known brands are not specifically included in the Argentine trademark law as a special category of trademarks, as I guess it's the case, I think, in Brazil. There is a special registry for well-known trademarks. It's not the case in Argentina, but they have been recognized protection through court rulings, especially in cases where a third party applied for a registration of a very well-known trademark without the authorization of the legitimate owner, or if they're using it on an unregistered basis. So there's been court rulings in Argentina for many, many years. The first case I remember that we all had to study was the trademark La Vache qui rit. It's the famous brand for French cheeses, where someone in Argentina had registered the trademark without the authorization of the French company. And when the French company wanted to do business in Argentina, they had to file a cancellation action against the Argentine entity, and without having acquired rights in Argentina, and they were able to obtain this. So well-known trademarks have been very well protected in Argentina for many, many years. So, but of course, it's very important not to, when you're planning to do business in Argentina and you are the owner of a well-known trademark, not only rely that you have a famous trademark and that the court will eventually recognize that you have a better right. It's important, as I said before, to have the trademark registered in the main class or main classes of interest, or even in classes where you're planning to use Argentina in the future. So it's very important to seek protection. Prior to avoiding a court action, what is usually done, depending the case, some clients prefer to contact the owner of the trademark, requesting that it be assigned in favor of the legitimate owner, or they prefer to send a cease and desist letter to the infringers requesting they cease use, and they withdraw if it's an application, that they withdraw the application, or if it's a registration, that they assign the trademark without any cost in favor of the legitimate owner. So those are the main tools that usually, not in Argentina, I understand it's the same in most jurisdictions, but it's always better to, in order to be in a better position, to already have a trademark right already owned in Argentina to attack infringers.
Very good, Ricardo. I really appreciate you taking the time today to share some of your insight into Argentine trademark law, and thank you for being on the IP Fridays podcast.
Thank you very much, Ken.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.